welcome, and thank you all for coming back, breaking away from your beef bourguignon, or whatever else you had for lunch. We're really excited to be here and to talk about securities litigation. So I think, as Andrew mentioned this morning, today there's some of the sessions are more focused on particular areas, and this one is focused on securities litigation and global trends. I'm not going to read out everybody's bio. I'm going to ask Daniella, Jared, and Trip to introduce themselves, say a little bit about themselves and their practice and their experiences of securities litigation, and maybe just to get the ball rolling, identify a couple of trends that they're seeing in their practices and at the moment in securities space. So I think we'll just go down the line. Daniella, if I can ask you to start.
Thanks, Andrew. My name is Daniella Strik. I'm a partner at Linklaters. I'm heading the Dutch litigation department as well as our firm's global collective redress group. And in that context, I also deal with securities litigation. So most recently dealt with litigation as well as settlement in the Steinhoff case, where our firm acted on behalf of Steinhoff. And currently acting on behalf of the non-executives of Airbus in securities litigation in the Netherlands. So if you talk about trends, I think I immediately have, when referring to these two cases, a good example of a trend that's multiplicity of claims. So that you have various securities litigation ongoing either in one country or in multiple countries, and we'll come to that later. Another trend we're seeing is that where we have the traditional securities litigation following fraud or failures to disclose in relation to M&A, that there's a broader range of topics where you see securities litigation being initiated for failures to disclose, for instance, in relation to compliance issues, and then failures to disclose, well, that you have the compliance issues as a company, but also that there are regulatory or criminal investigations ongoing and what the estimated amount of the fine is. I think those are important trends.
Hi, so I am Jared Gerber. I'm a litigation partner at Cleary, Gottlieb. I am located in New York, so I bring the US perspective to the panel, hopefully. My practice has dealt with a lot of, very big securities class actions and other securities litigation in the U.S. Given that my firm is very international, a lot of that has involved cross-border cases where there have been multiple cases brought in different jurisdictions where we've had to coordinate. We worked on the large Petrobras matter that Jeremy Lieberman talked about from the other side yesterday, which had companion litigation in the Netherlands, and then also in Brazil and Argentina and elsewhere. I've had cases with cross-listed companies in Israel and Canada, each of which have their own different slants on the class action device and raises interesting issues in my practice. In terms of trends, there's an endless number of trends in securities litigation in the U.S. We go through these waves of cases where, whatever happens to be in the news that day is the hot trend in securities litigation. So there was a wave of cases around COVID and the impact that had on companies, then supply chain issues that had on companies. As of late, there's been a large number of cases filed against something called SPACs, special purpose acquisition vehicles. They're a different way of going public that had a bit of cachet in the U.S. A year or so ago. It became sort of the main way that companies were going public. It's a blank check company, so it's sort of a shell company that just raises money from investors to go out and acquire a private company to bring public. It involved, over time, I think, sort of increasingly dismal view of the prospects of those companies. It attracted a lot of celebrity investors who maybe were not super qualified, so there was sort of a dim view of the companies that they selected. And then it also involved a lot of early stage companies, a lot of companies that were thinking about developing the next new technology, electric cars, electric trucks, recyclables, plastics and straws, that sort of thing, where they just had the germ of an idea of a product and not yet an actual product. And after they went public, I think it became clear that maybe some of those companies were a little more optimistic in giving projections than they otherwise might have. So a lot of those have gone down in price and have led to a lot of securities litigation. I would say, too, a lot of the topics from other panels have led to recent securities litigation in the U.S., maybe not surprisingly. The cases that you guys bring have, important issues and impose the threat of real liability against companies, so that can have an impact on the stock price. So we've seen a lot of cases about data breaches in the U.S. When companies suffer data breaches, it often impacts their stock price and leads to claims that they misled investors about their data security. You see it, there was a mention of Forever Chemicals this morning. You see that when there's litigation against companies about, Forever Chemicals or a product liability issue to a company, it leads to a lot of follow-on securities litigation. Same with antitrust matters that we've heard about here. And there's a fair amount, actually, of securities adjacent, antitrust adjacent litigation about the rigging of various rates or various securities over time. One other key trend that has come up that has been in the news as of late, so I imagine will come up even more, is cryptocurrency, digital assets. A lot of the initial litigation in that space in the U.S. has been questioning whether they should be regulated as securities. Are they actually securities rather than currencies or something else? If they are a security, they would need to be registered, and the companies that issue them, develop them, don't view them as securities, so don't register them. So there's a fair amount of litigation in the U.S. already alleging that various cryptocurrencies, digital assets, are securities, and that investors in them, or purchasers of them, not to take a view on whether they're securities or not, should be able to put back their purchases if they've suffered losses because they weren't properly registered. That's something the SEC has focused on a fair amount. My firm is handling one of the main cases that the SEC has brought against Ripple on that area, but it's also prominent on the private side too, with a number of firms bringing those cases. And I think we'll see those cases sort of regardless of whether the cryptocurrencies and digital assets are considered to be securities, drift over time into fraud claims, just given what's in the news these days. I think we'll see an increase in that.
Good afternoon, everyone. My name is Trip Chong, and I'm Director of Business Development at Broadridge. Broadridge is a global fintech that provides financial services to the finance industry. One of those services are global class actions monitoring, filing, and asset recovery service. I've worked in this industry for coming up to 15 years now, started with the claims filing side and moving on to operations, and then to client services. But in the past few years, I've been working directly with law firms and litigation funders to assist our institutional investor clients in their participation in non-US cases. So just two high-level trends that I'm sure we'll go into further detail as we have this discussion. The first, and I think there's a panel straight after us that's going to be talking about this in a lot more detail, but claims that are deriving from ESG and how institutional investors are responding to these cases, and I think we'll delve into that a little bit later. And the second a trend that we're seeing from an investor perspective is the rise of competing actions and how investors are sort of managing to navigate this increasingly competitive space. So I look forward to drilling into those two a bit later. Thanks, Andrew.
Thanks, everybody. So I think it's a nice little setting the scene and a quick survey of each of the panelists and the jurisdictions in which we operate. I should just say for my own self, I'm practicing as a securities group action, class action, collective redress, practitioner, whatever you call it, in England, because we don't have a regime, outside competition. It's, you know, we don't really have a term for it. But anyway, group actions, securities litigation, acting for institutional investors, TRIPS clients, and many others. And I've been focused in this space for about 7 or 8 years now. I was involved in the first of them in England against Tesco, and I had the good luck of suing them twice for 2 different investor groups, which is a point we might come onto as we discuss you know, the difference in England, the opt-in system, you know, the fact that you can have multiple groups suing a defendant multiple times, whether that's a good thing or a bad thing for either side, I don't know, but it's a feature of the English system as it sits at the moment. And then a while ago I practiced in Sydney, so I can give a bit of an Australian perspective as well, as another jurisdiction to cover off, where class actions are obviously very active, and particularly shareholder class actions. So I think we've set the scene, I hope, for everybody, and we're now going to try and pick out a couple of those common themes or trends, as the title of our panel suggests we should. The first one Daniella picked up on, and so did Trip. It's this question of the multiplicity of claims, I think even within a jurisdiction and then across jurisdictions. And I think the interesting point from an investor's point of view, and which is why I think it's great to have Trip on the panel to give the client side perspective, is, well, actually, it's either a challenge or an opportunity, depending on the jurisdiction. You know, to look at it positively, investors have choice in some jurisdictions, but how do they go about deciding if they have that choice? What are the factors they take into consideration? Whether they sign up to my group or somebody else's group, what's all that about? How do they do that? Hopefully it's not just a beauty parade, because I won't win. But Trip, what do you think from the investor's point of view? How are they approaching this sort of choice?
Yeah, I think dealing with multiple case proposals can be difficult given the challenges an investor faces when just looking at one. And we, you know, off the face of it, the legal claims are pretty much the same. So it's about understanding how each proposal is different. So at Broadridge, we have a sort of comprehensive checklist that we have in place that basically compares all the different proposals, and we sort of hitting the key points. So when we're presenting this information to our clients, they're able to see where each proposal differs. And we would also encourage law firms and funders to come and talk to us at an early stage to discuss these cases, so we can start putting together that information and really building on that communication that we will be, you know, eventually when we go out to our clients. And I think a good example of this is actually the Danske Bank case, which I looked at a few years ago. And I think the total number of proposals that I looked at was 11 in the end. And not all of those were viable options, obviously. Some, for example, didn't have a local Danish counsel retained. Others didn't have a full funding package in place. So, you know, from my perspective and from our client's perspective and from the law firm and funders' perspective, it's just not a good use or an efficient use of time. You know, at the end of the day, we want our investors to be joining these cases. And, you know, I think sort of overwhelming them at the first hurdle is probably not the best way to sort of do this. And I think one of the challenges from a funder and law firm perspectives is the book build. It's particularly when you're talking about competing claims. And it's difficult to get clients moving and clients committed when there's so many options on the table, and especially when there's not a statute of limitation issue. So, you know, who moves first, effectively. But I think it's not necessarily about the sort of first case out of the gates anymore. I think we're sort of beyond that now. many investors, perhaps in the past, would look at cases to, see which is the biggest investor group and try to find some comfort in that with their like-minded peers, like-minded sort of investors. But I think that it has changed. I think lots of investors are now perhaps looking at smaller investor groups with sort of higher value groups, sort of looking at these sort of cases that might be under the radar slightly. And I think it was mentioned on the panel yesterday about, and something I have experience in as well, as about the proposition of a private action. Many clients will be looking at these cases, looking at all the proposals, realizing their damage levels are extremely high and thinking, well, actually, I could go this alone, or we could, there could be a couple of other like-minded sized investors that may want to go with us, and we'll sort of litigate this privately. And that is a really good proposition, I think. Also in terms of fees, so, obviously, with each proposal, clients will be looking at the fee levels. And again, I don't think it's about opting for the cheapest deal anymore. Maybe in the past it may have been, so you get more of the pie at the end. But I think that has changed in terms of like the more sophisticated investigator looking at this. But having said that, I think fees do obviously need to be competitive in terms of law firms and funders. And I think the good news is we are sort of heading in that direction. We are seeing competitive fees now. And I think another thing that we also look at, and Daniella and I were speaking about this earlier, was the loss estimates and methodology that's used for these cases. So obviously, if we have multiple proposals, an investor will be looking at what their potential exposure looks like. And we've seen wide-ranging levels for each case proposal. And obviously that's due to the class period in play, the methodology that's used. It can differ per proposal. But I think now investors are really putting those figures under scrutiny. Those figures will be tested. And just listening to the panel yesterday, these claims, some of these claims can be incredibly complex and, come into these calculations. So I think it's really important that we are able to translate that methodology to our clients, be able to sort of realistically say, this is what your potential exposure looks like, and this is why we think this is what these figures mean. And I think being able to translate that information could really make the difference in somebody, an investor joining one case over the other, because those figures need to sort of stand up and stack up. And I think just finally, if there's a new jurisdiction that comes online, like the Danske Bank case, many investors hadn't ever opted into a Danish case before. I think there needs to be transparency from the outset. So, what are the requirements of an investor? What is it they're likely to do? Is there any nuances in this jurisdiction that they need to know about? And giving that information at the outset, even if it may be an unknown, it's always worth sort of giving the client a heads up to say, this is the direction we see this going in, and this is what is going to be expected of you. So in terms of, for example, in the Section 98 claim, as you very well know about, Andrew, what's the reliance questionnaire going to look like? Is this something, are these questions I'm going to be able to answer? And is this information I'm going to be able to provide further down the line to progress my claim? Is it worth me putting in that time and effort? And I think a good example of this, in this case, as you mentioned many, many times over these last 2 days, is the VW Dieselgate case, which I had the fortune and sometimes misfortune of dealing with. And in that case, there was an unprecedented level of supporting documentation that had to be provided, just to support this claim, and way beyond anything we've ever seen before, which is good now, because at least we can anticipate potential cases in Germany. And it was a great defense tactic, actually, and successful to some extent, I would say, from the defense team, because the clients that I was sort of looking after at the time did withdraw from the action and said, actually, we just don't have the time and resource to be providing this kind of information. and ultimately did sort of withdraw. So I think there's lots of different sort of checkpoints that we as a provider and an investor should be looking at when looking at these multiple case proposals. And I think they're all very important, but I think what we've done now is, well, where we're at now, is that there's been a real shift in scrutinizing these cases much more, simply because there's so much more out there in terms of volume.
Yeah, what I found interesting, so I typically act on the defense side, and we never see the proposals, we just see the claims coming at our clients, and then with multiplicity you sometimes wonder, why are certain investors choosing one plaintiffs group or the other. What I found interesting from what you said was the scrutiny on essentially the damages theory, right? Because it's, I think, a really important part for a plaintiff group to be effective, to have a good theory, and also to be able to get a settlement, and when. Because some of my clients, they look at those hugely inflated amounts in their view, and they say, well, these cases are not settleable. It's just too huge. And if there's no proper substantiation, that's an issue for that as well. And that sometimes we also see if the relevant periods are very long, there are very opportunistic events included in the relevant period. For instance, if you say you want to sue a financial institution and you stretch the relevant period to encompass the pre-financial crisis, there has been a huge price difference over a decade, for instance. But if you make the period smaller, then the loss will be less. So it's really important for investors to scrutinize that, I think.
Yeah, I would say from my perspective on the defense side, the multitude of actions across different jurisdictions really is more of a challenge than an opportunity. Speaking from the U.S. perspective, there are really significant procedural differences across the jurisdictions. In the U.S., for example, the plaintiffs can't get discovery in a case until they survive a motion to dismiss, which is not the case in other jurisdictions. So there can be very machinations about how to keep the discovery from the plaintiffs in the U.S. that you're giving out elsewhere. There are also different, standards, obviously, across different jurisdictions. And the Danske Bank case that you mentioned is one example of that, where the case, in the U.S. was actually dismissed in an early stage. They brought a case about the ADRs that existed, and it was dismissed, notwithstanding the misconduct at the company that was pretty clear. There were it didn't meet the sort of heightened pleading standards in the U.S. and the standards that were set forth for when you need to admit wrongdoing or not, that are pretty stringent in the U.S., which by itself would have been a great victory. But in a whack-a-mole world, it's a victory in the U.S., but the investors can just shift overseas, which can be somewhat frustrating on the defense side.
Yeah, and overseas, if that's Europe, it's not much better in that respect, because in individual EU member states, there are hardly any rules on lease pendants. So if there are multiple collective actions or even group actions, or how do you call them, there's no way to get a proper order on that, mostly, except for now in the Netherlands, where you have this new legislation with the exclusive representative. So there's some kind of, for the defense side, an improvement. But we still have to see how that will play out with carriage disputes, etc. And if you look at litigation being initiated in different EU member states, and there's a problem that there is a rule on lease pendants. But for instance, there's a question in collective redress. Are the parties the same? So is then the court that is second being called on obliged to stay the proceedings until the first court in a different member state has accepted jurisdiction? While the representative groups may be different, but they, at the end of the day, represent the same class. And also, if they are not regarded as the same parties, whether then the court will stay the proceedings, because the courts can stay the proceedings under the Brussels regulations. But we see a tendency that national courts, they want to hang on to those cases, so then cases may progress in different member states.
Okay. Jared, I just want to pick up on a couple of points you made. You talked about, and I guess it's an example that we're seeing more and more, and I suppose we should just expect to see it, but American depository receipts and a US class action, I mean, well, I guess we're 10 years post Morrison and National Australia Bank, so that has resulted in investors, US investors, having to look outside the US. But nevertheless, ADRs exist, and if they're buying ADRs on the New York Stock Exchange, that's a security that they can, or gives them a cause of action if there's been misleading conduct. So I've faced this situation a few times where I'm looking to bring a claim against an English-listed company. Tesco is a good example. There are others where a US class action is already taking place because you guys are so fast to get to court. And it seems...
Not me, the plaintiffs.
Well, the plaintiffs.
Yeah.
And then oftentimes really quick to settle. And I guess it just creates an interesting dynamic for us because we have to deal with the settlement that might have been achieved or obtained in the US, and does that set a floor or a ceiling for what the defendant might be willing to pay. But I guess it just demonstrates that even in a securities context where you're normally thinking in a simple analysis, where's the company listed, the litigation, the securities class action logically should happen in that location. But as we've been talking about, it's going to happen actually in multiple jurisdictions, even notwithstanding that listing. And ADR cases are a good example of that.
Yeah, that's right. So the Morrison decision, which I think might now be 12 years old at this point. Happy birthday, Morrison decision. Set out two categories of claims that can be brought in the U.S. One is securities that are traded on an exchange. So obviously ADRs for foreign companies would fall under that category. And then separate, somewhat more nebulous, other domestic transactions in securities. So that typically arises with securities that are not traded on an exchange. They might be listed on an exchange, but not traded on an exchange. So a lot of companies have debt securities, for example, that are not traded on an exchange. So those often can get swept into a U.S. class action too, in addition to ADRs. There's been, over recent years, a bit of a recent trend of attempting to sidestep Morrison in a way where you bring, or a plaintiff brings claims about ADRs or whatever securities are actually traded in the U.S. by a company. And then, even though they can't bring under Morrison claims under the federal securities laws about foreign securities, they try to bring foreign law claims and say that they arise out of the same facts as the U.S. securities law claims, so the court should consider those. And we've seen that in a couple of cases. There's a Toshiba case that's pretty prominent that brought Japanese law claims in addition to the U.S. securities law claims about ADRs that were at issue there. Those cases aside, though, when you have the litigation in the U.S., it does tend to be focused on the ADRs and not the foreign underlying common shares. So any dismissal or settlement of those claims doesn't tend to cover those other securities that aren't an issue in the U.S. So they can proceed separately.
Yeah, so we do see then, and we have multiple group actions or class actions in different jurisdictions. Again, as you say though, concerning the same fact pattern, the same stock drop. Daniella, I wanted to ask you about the Steinhoff example. That was a company listed, I think, in several jurisdictions. So immediately you had that potential question arising.
Yeah. Yeah, it's also interesting to look at the theories that were used by the plaintiffs to sort of anchor the case in certain jurisdictions. So we had a multiplicity of defendants, so that already gives an array of different jurisdictions. So it was the company. Actually, there were two companies. So the currently listed company, which was a Dutch entity, as well as the formerly listed company before the restructuring of the group that was based in South Africa. And had a listing in South Africa, and the currently listed company had a listing in Frankfurt, Germany, as well in South Africa. And then there were all kinds of co-defendants, well, former board members, accountants that had residence in different countries. So then you had theories about, well, the place where the defendant was located, or whether the claims against the co-defendant next to the Dutch or German anchor defendant were closely related to those claims as well. And then there was also a debate about in which country the damage had been suffered by some of the investors. And that, well, meanwhile, in Europe, we have the VEB BP judgment of the European Court of Justice that also was about a case where there were multiple listings and where the court held that ultimately courts had jurisdiction in the event the company had to fulfill certain reporting requirements in that country, or those countries, I should say. So you could have multiple competent courts in one case. And that also, the next question will be, well, which law will apply in that respect? And there's similar theory and debate to be had about that.
And Trip, just coming back to you, from the investor perspective, I suppose it'll depend, if we're using the Danske Bank or the Steinhoff example, well, essentially, what shares were they holding? What securities did they have? Did they have ADRs? Were they buying off the London Stock Exchange, Johannesburg Stock Exchange? And in your portfolio, I imagine you have clients who do have those sort of multi-jurisdictional investments.
Yep.
And then I sort of feel like we're coming back to the question of choice again, investor choice. And do you think it's, what are they looking at? Is it the biggest loss, or?
Well, investors are ultimately always going to claim where they can. So any opportunity where they can claim, investor losses they can, especially if they're using a provider like Broadridge. In fact, I got asked this question just a few weeks ago on the Airbus case. So there was an ADR case in the US which settled, and the client, we did file recoveries on behalf of the client for that case, and then they wanted to explore options about a stichting in the Netherlands. So, it can be complicated and complex. We obviously, as we hold the data, we're able to identify where the client has been impacted, and obviously then pursue those claims if we have the ability to do so, if we're able to, obviously, and we do that by communicating with our law firms and funders whenever we can. But I think in terms of the US, just mentioning a point about what you were saying, Jared, and that I think investors do follow what's going on in the US, and we certainly follow what's going on in the US. So it's likely that if there is a big settlement in the US, there is going to, it's like a litmus test almost to what's going to potentially come out of the US and be replicated particularly in Europe. And I think a really good example of that is the FX claim. We saw the settlement a few years ago for 2.4 billion, I think, I can't remember what it was, 2.4 billion. And then we obviously saw the claims then being on an opt-in basis in London and the UK, which now we have 2 CAT cases, and we also had some opportunities in the Netherlands as well. So, there's lots going on, and I think the US is a really good sort of indicator as to where, we're going to be busy next, I think.
Oh, well, I think that's right for all of us, actually.
Yeah.
But on the flip side, again, coming back to the ADR cases, but, the Tesco ADR case settled for about $10 million. And actually that was kind of annoying for us because we had lots of investors saying, well, that's a really low settlement. What are we going to, is it going to be worth it? for us to, what's your theory of loss? What can we expect why would we participate in English litigation if the returns in the US were so low? So it can operate both sides, I suppose. And I guess talking a little about the English position, securities litigation, I think these questions, the answers differ depending obviously on the jurisdictions, but whether at a high level, opt out or opt in, something we always talk about at class action conferences, it does have a real impact in this space, because for the opt-in regime that we have, or non-regime that we have in England for securities litigation, from the investor's point of view, and also, frankly, from the claimant lawyer's point of view, it respects choice. So the English respect for freedom of contract and investor choice. If Trip's clients choose to join my group, which I hope they always will, that decision will be respected. And we, for the moment at least, in securities, there shouldn't be a need for a beauty parade or a carriage dispute. We filed a claim against Glencore end of September. And within 24 hours, 3 other law firms did as well, Quinn Emanuel, Stewart's, and Palace Partners. And, on the one hand, I wish those clients had have signed up with me, but as long as I've got a group that's big enough or with damages that are commercially viable, then that's fine. I don't mind if there are 2 or 3 other firms acting for their groups, because we will collaborate with each other and cooperate, and whether we need a GLO on top of that to make that happen, it depends. We don't need to. You don't necessarily have to. So, we can divide the work between ourselves, and we can cooperate as the court would expect us to do. So, as an Aussie coming to London for a long time, I couldn't believe that there was no class action regime for securities litigation or any commercial cases outside the relatively new competition sector. But actually, I can see the benefit of an opt-in now when I'm focused on this area 100%. The book building is difficult or challenging, but it's achievable. And then once you've got your group, you can move forward, and you don't have to worry about. I can imagine from a funder's perspective, also from the practitioner's perspective, the FX carriage dispute is a great example in the CAT, in an opt-out regime. Both of those firms, I'm sure, would and still probably will, one of them at least will, do a fantastic job for their clients. But they've invested a lot of money, a lot of time, and then for the court to say, you can move forward, but you have to stop. That would be, frankly, it must be devastating if that happens. And at least in my space, I think for the time being, that's not going to happen. So we have enough challenges as it is, but we can avoid, in England at least, carriage disputes. And but across jurisdictions, it does come up, and it is an issue, and whether there needs to be a policy decision or rules or statutes put in place to allow for a resolution at that point, I don't know, but we kind of deal with what we've got and try to make the best of it. Mentioning Australian cases, I just thought I would touch on a very recent example, which is a shareholder case against BHP, the miner, in relation to the collapse of the Fundão Dam in Brazil. And there's been a recent decision of the Australian High Court only in October, which has confirmed that there are no geographical or territorial restrictions on plaintiffs or persons as they're defined in the relevant act. And that's an interesting situation because BHP was listed in London and in Australia at the same time, and also in Johannesburg. And the estimates suggest that more than 50% of the value, or 50% of the shareholders, had bought on the London Stock Exchange and the Johannesburg Stock Exchange. And the question of whether or not they were part of the class as defined in the Australian class action was tested by BHP, and they lost apparently at every level, but they took it to the the High Court of Australia, which is the ultimate appellate court, and that court only in October confirmed that there is no such restriction. So it poses an interesting question for me, because I think in the US example, Jared, jumping back to you, there is the concept of, as in any opt-out regime, you can opt out, that's the point. And then investors could bring a direct action themselves. And I guess, Trip, that's a point you made too, depending on the value of your losses, do you actually want to be in a group action? Or do you want to choose your lawyer and in your direct action? Have you had any experience of defending direct action?
Yeah. So it is something that's been a prominent feature of the U.S. securities litigation landscape for, I think decades now, and it just keeps increasing over time. I think for a while there was a sense that opt-outs from securities class actions could do a lot better than the settlement for the entire class. And there were some prominent examples of that where, typically large institutional investors, pension funds, opted out of settlements against, it's been a while, AOL Time Warner, I think, and Quest, maybe, there was a Q case. And they did something like, 2 times, 3 times, 4 times better than they would have done if they had stayed in the class. In large part because, once a company settles the class, they're hoping to put the litigation behind them. And, here comes this large investor who has some leverage to say, we're prepared to litigate this hard, impose costs on you. Do you want to do that? And the way to avoid that is to, pay them more. So there was and continues to be, I think, an increasing wave of that in the U.S. trying to, seeing plaintiffs opt out after a settlement is reached and trying to extract more than they would have gotten in the settlement, where the class settlement, in effect, becomes the floor for their separately negotiated settlement. I'd say the dynamics on that have changed a little bit in recent years, though, because of some of the statute of limitations, statute of repose issues that have been litigated over time, where it pushes institutional investors to, I think, make that decision earlier than they had in the past. So they couldn't just sit and wait until the settlement because, 3 or 5 years may have passed by that time and they wouldn't be able to bring a timely claim. There's been a bit of a swing back where those decisions are being made earlier, and there's an ability to sort of coordinate those individual opt-out claims with the class action, and you sort of see the dynamics of the opt-out plaintiffs, the opt-out counsel, and the class counsel, fight with each other or squabble over who's going to lead things or take depositions and the like. That has swung it back a little bit and changed that dynamic a bit.
It will be interesting to see how that will develop in the EU, where the EU Collective Redress Directive will be implemented in the coming period, particularly on carriage disputes, whether there will be an exclusive representative that will be allowed to represent the class, so to speak. In the Netherlands, we have that now in the new legislation, but we're still to see how the courts will deal with those disputes, what the exact criteria will be that they will be using, and also how the different plaintiffs groups will respond to that, whether they somehow will cooperate, because you see a relatively small group that you see in various securities class actions, and one day they may be the exclusive representative and the other day not. But the point is, if they opt out, so if a competing group opts out, that in principle the court will stay those proceedings, so they can't have a competing class action, and the individual actions then can be stayed for a year. And that's also interesting to see whether the courts will use that discretion as well. But it will be pretty devastating if you're sort of second in line in the carriage and you have to wait, I guess. Yeah, and I mean, this is you've touched on another point, and which occurred to me in the BHP example. If I managed to book build a group of investors who'd bought on the London Stock Exchange now,
ignoring the limitation deadline, that's probably passed, but in this hypothetical, if I could get a group to sue in England, what would BHP's response be as a defendant already in an Australian class action? Presumably they would come to London and file an anti-suit injunction or something like that. But then if the investors have opted out of the Australian action, they can't be forced to stay in. So I don't know whether I've left it too late, but it's an idea that potentially, I see these things as opportunities as well as challenges. But I guess it just shows, the complexity and the multiple factors that are in play. Even when you think of securities litigation, as I said before, which should be a pretty simple thing. The company is listed. Where is it listed? That's where we'll sue. But as we see in practice, often there'll be multiple listings or there'll be ADRs in a different jurisdiction.
Novel theories, not to forget.
Yeah, exactly.
About jurisdiction.
Exactly,
Yeah.
exactly. So it becomes, as lawyers do, we turn things simple into complex. Lots of opportunity, I think, and work for all of us. This is a panel about global trends in securities litigation. As Trip said, we have a very eminent panel coming up right after us about ESG claims. But certainly we thought we couldn't not talk about, or at least mention, ESG claims in the context of securities litigation and global trends. Trip has already mentioned it as something that your investor clients are thinking about. So do you think, I look at it from in two respects. It helps to analyse the alleged wrongdoing of the defendant, and then also it helps me in conversations with investors about their own ESG commitments. If you say you're committed to this space, here's a case that could expose wrongdoing, you should join and participate. Do I still need to show the big losses, or are ESG factors now ranking?
Yeah. Look, I think monetary recovery is always going to be a key motivator. Once everything's been taken into consideration, an investor's going to say, look, do my level of losses warrant further participation in this? But I think, for most cases, probably the last 2 years that we've looked at, certainly, are ESG derived. So we're definitely looking at more and more of these cases. But I think there has been a definite shift in client perspective when we look at, and they're certainly looking at these cases with an ESG lens. And a good example of this actually is I spoke to one of our clients who's a London-based asset manager. And 5 years ago, they were happy to look at the opt-in cases, happy to look at their losses, but never really pulled the trigger, never sort of moved on these cases. But now they said to me they can't afford not to look at these cases, and it has definitely changed. So, because this is now part of their ESG internal policies, securities litigation sits hand in hand with what they're doing for their ESG policies. So I think using litigation as a tool to really drive this corporate governance and directly address this corporate wrongdoing, but while still protecting that long-term investment, is definitely a key motivator now for clients.
And I think a lot of focus in ESG goes to the E, but as security litigators, we all know that securities litigation has always been at least on the G, on the governance, failures to timely disclose, accounting irregularities, etc. So I think we're in the middle of the action.
Yeah, I think governance and stewardship has always underpinned the motivations for clients, always. But now I think we have this new sort of, whole ESG sort of concept, which sits nicely with where this all needs to go, I think.
I would say from the defense side, from the U.S. perspective, there is a real expectation that ESG will be a very large wave of cases in securities litigation going forward. We're a little bit behind the curve in the U.S. in terms of the regulatory requirements around ESG. went 4 years without having a government that believed in regulation. So we're just catching up to you guys in Europe in terms of requiring disclosure in this area. Companies are taking it very seriously and are really thinking very closely about, how to get the systems in place to make those disclosures, how to ensure that they're accurate, because they realize that investors are focused on it and taking it seriously, and they have their own mission on the corporate end to improve environmental issues, in part because it's important to the shareholder base. I would say from the sort of defense perspective, I think you hit on an important issue, Andrew, which is will it actually impact the stock price? We already have and have had over time environmental cases. The dam collapses, the oil spills, those types of cases have been brought because, there was a big impact on shareholders and the stock price went down. I think those cases will continue to be brought. I'm a little more skeptical that we'll see the cases about, your scope 3 emission calculation was slightly off. I don't know that that's going to, be something, at least in the short term, that investors are going to have a huge reaction to, that's going to cause a big stock price decline, that's going to make it worth bringing an expensive securities litigation over it. Maybe that changes over time, but I think where we are now, there are strong practical reasons and strong materiality arguments that would be obstacles in that type of case.
Yeah, I think that's right. And I've had some really interesting conversations over the last year or so with a couple of NGOs in the climate space. And, I've been incredibly impressed by the level of analysis they do and the campaigns they run, looking really almost in exactly the same way that I would approach the case. What is the company saying in its, the narrative section of its annual report? What's the company doing, or how is it reflecting that in the financial section of the back end of the report? But in my conversations with them, I've said, look, from a securities litigation point of view, ultimately, if we could, for me to be able to bring a case, there needs to be some loss. The market, the investors, or the stock price has to have an impact, or has to be impacted to give you the cause of action to move forward with. And I think obviously in extreme examples like BP and Horizon or BHP and the dam collapses, that will have an impact on stock prices and will give rise to effectively follow-on securities litigation. And maybe, sadly, sometimes we'll see revelations that don't have an impact on the share price, which you might have thought they should, but we just have to leave it to the market to make that decision and respond where it does. I think we're probably, I'm getting the signal that we've filled up enough time. Yeah. Okay.
We have a question from the online audience, which
First
would be the last thing. So if you could do this maybe in 1 minute, that'd be grand. Are there any trends being seen in how courts are approaching securities claims from a procedural perspective? For example, Andrew will be aware of the apparent shift in the form of split trials in the English courts and the availability of other procedural routes for pursuing these claims. That question is from Keir Baker online.
Well, certainly in the English perspective, there's a lot of development at a procedural level. Split trials, bifurcation, it is a mechanism or a strategy, a structure that we try to adopt because it helps us kick off into the long grass for as long as possible, individual investor issues like reliance or losses. So split trial absolutely is something that we will always be asking for, and there have been 3 decisions of the English High Court this year ordering a split trial in that way. It's still not a perfect division, it's not quite as good as I'd like it, but it's much better than not having a split trial. And then I think there's plenty of life in 19.6 and representative proceedings for securities cases. I know it didn't work in Lloyd and Google, but 12 months since that decision, I think securities litigation, fits that dynamic really well, because you can really, in a sense, you can make a product liability analogy. The shares have been impacted by the wrongdoing to the same extent. Just BlackRock might have 10 million of them, and I might have 5, but our loss is the same on a per share basis. So I think, yeah, those changes are coming, I think, is my answer to that question.
Yeah, and in the Netherlands, we are seeing, particularly under the new law, that there's sort of a bifurcation pattern developing. So first jurisdiction, then admissibility, then potentially applicable law and/or immediately the merits. Maybe it's too early to call whether it's a true trend, but if we look at different collective actions, we see certain courts trying to move the damages discussion to somewhat more the front, and then it's warranted on the basis of the merits, so even before the liability has been established. And potentially there is a drive for courts to try to get parties to get a grasp of whether the case is settleable or not, so they can get rid of the cases in that manner. It's interesting to mention.
Do we have any other questions from the floor? Where's David? You always have a question.
Mm-hmm.
Oh, sure, okay. No trouble. Well, I think that's time for us then, obviously. We'll vacate the stage. Thanks, everybody, particularly for a Friday afternoon, post-lunch. It's good to see you all. And there's lots to talk about, so we'll see you next year. Thank you.